for this historic moment and exercise, and my apologies for not being capable to be present in person in the land of the brave today, which I really would have preferred. But I will try to give you the gist of my thoughts in the next few minutes, talking about environmental law and policy from a green hydrogen perspective, and with Namibia in mind while doing so. I hope that the audio-visual transmission works well, and I would like to start off then saying that Namibia is one of the driest countries in the world, with multiple deserts, and it has a pristine environment which is particularly sensitive. We have to keep this in mind, despite the opportunity space that we are discussing at the same time. Both Namibia's environment and the poverty aspect was mentioned, its population are particularly vulnerable, especially to the impacts of climate change in the face of water scarcity, land degradation, and drought. So that as a caveat before I start. And Namibia has embarked on a great opportunity road, green hydrogen, which needs to be brought in a wider picture of Namibian law, and I think Ms. van Beek has done a marvelous job in introducing Namibian environmental law, which makes it, of course, much easier for me to present here, as I don't have to repeat what has already been said. But what I would like to say is that Namibia has quite a number of policies in place that should find consideration on the way forward, and that is both Namibia's National Development Plan, Namibia's heralded Prosperity Plan #2, the Sustainable Development Goals, the Paris Agreement and the United Nations Framework Convention on Climate Change. These are national and international policies and laws which need to be followed in due process. The African Union Agenda 2063, Namibia being a member thereto, also to the African Free Continental Trade Area, and the SADC Regional Indicative Strategic Development Plans. These are regional instruments which may also unfold more and more relevance in the context of green hydrogen transportation, export, import, and also the sustainability aspect. So with this in mind, I would like to say that we should not forget, despite our ambitions, that the real value of Namibia's environment is to be considered as a scarce water resource country with conservancy obligations. Human rights have to be respected, especially of the vulnerable and indigenous communities, as well as fair and equitable labor conditions. Now you can see in front of you the slide on environmental law and policy, and I would just like to know whether you can still hear me, because I see that there's an audio connection problem. Can anyone give me some thumbs up whether this still works or not? Okay, excellent. So with that book, I would like to give you 830 pages at hand, dealing with all the different environmental sectors, from the constitution downwards to legislation, to policy, water, land, the atmosphere, climate change, trade and sustainability, human rights and the environment, and so forth, from both a domestic, regional and international law perspective. This is the 4th edition of this book, which came out recently with the support of the Hans Seidel Foundation. And it is freely available at the Hans site to be involved in this discussion, because only if the general public, but also the legal fraternity and the industry investors understand that Namibia already has a legal setup that cannot be entirely ignored, despite the fact that perhaps some of the laws may be outdated, as has been stated. Legal process is an ongoing process. So we do not reinvent the wheel just because we have a new form of the industry that is emerging. Our constitutional principles, such as Article 1, where the Constitution is above any other law, have to be considered. Article 100, which vests all natural resources in the state, has to be considered. And Article 95, to protect the environment for the present and future generations of Namibia, has to be considered in due course. And therefore, the Environmental Management Act is the piece of legislation, despite the fact that it may need certain amendments, and I think we will have a discussion around that shortly after that. It is a piece of legislation that can well accommodate the needs and requirements of these new industrial processes that have several implications on the environment. So far, and that is correct, Namibia has no law that directly speaks to the implementation of green hydrogen projects. So in the first place, I think it is laudable that the government intends to establish a strategy to move forward. And with such strategies, certain legal amendments can also be triggered in due course, because of course there are environmental implications involved. Hydrogen is, for instance, a highly explosive, flammable gas, which also applies to its production, storage, transport, both subject to strict and regulatory requirements that require environmental impact assessment, classified installations for the optimal protection of Namibia's environment, and most importantly, of Namibia's people. So, taking that this new industrial processes touches on so many sectors, it is relevant to water, it is relevant to renewable energy policies and legislation that, of course, have to be critically analyzed and adjusted where need be. The question that I'm asking is, do we need to reframe the system? Do we have to reconfigure the legal setup in Namibia? The answer is no. I think the answer is that we need to respond in tailor-made responses where the need comes up in order to counter the legal void and in order to create legal certainty, which is also important for investors, for the Namibian population, for health and environmental matters. In that regard, I think we have to take advice from the international renewable energy agencies that says national policies for hydrogen economy ideally based on a national hydrogen strategy that also provides relevant legal definitions, policy priorities for hydrogen, guarantee of origin schemes, and other enabling policies. So in that regard, Namibia has to move forward when it comes to its national energy policy, renewable energy policy, independent power producers policy, to become fully operationalized, increase Namibia's benefit from multilateral cooperation, realignment of technical cooperation, and also, of course, its climate obligations, because COP27 is around the corner, and it has been mentioned this morning that Namibia has already aired its ambitions in this regard. So, to come to a conclusion, I recommend that due to a lack of clear hydrogen energy policies and legislation in Namibia, these should be formulated in a manner that incorporates research institutions, public sector, private sector, and more focused on achieving certain specific goals, such as decarbonization, alongside with economic benefits such as a scaled-up energy sector with wind, solar, and infrastructure and technologies. It is, in my view, most advisable to put legal safeguards in place that ensure that the pristine Namibian environment and those who are most vulnerable are not jeopardized in the process of the green hydrogen transition towards a green economy. The pursuit of environmental justice, equitable access to environmental resources, and the promotion of community well-being and empowerment are the socially just conditionality requirement of sustainable development, along with Article 95 of the Constitution, where both present and future generations need protection, and especially as is stipulated in the Environment Management Act, that the environment has to be protected in a sense where the polluter pays and where the precautionary principles and the principles of national and international environmental law find full consideration. Thank you for your attention.